Case summary. Case name: New Zealand Shipping Company Limited v.A.M. Satterthwaite and Company Limited, the Eurymedon Court, Judicial Committee of the Privy Council, year 1975. Citation: 1975 AC 154. This case addresses the issue of whether a third party, not initially part of the contract, can benefit from an exemption clause within that contract. The key legal principle revolves around the doctrine of privity of contract and the exceptions that may allow third parties to invoke contractual terms. Background facts: claimant, appellant, New Zealand Shipping Company Limited. Defendant, respondent, A.M. Satterthwaite and Company Limited. Facts: A.M. Satterthwaite and Company Limited, an importer, contracted with a carrier, the Federal Steam Navigation Company, to ship a drilling machine from Liverpool to Wellington. The contract between the shipper and the carrier included an exemption clause that protected the carrier and its servants and agents from liability for damage to the goods. The machine was damaged during unloading in Wellington by New Zealand Shipping Company Limited, acting as the stevedore. A.M. Satterthwaite and Company Limited sued the stevedore for the damage. Arguments. Claimant's argument: New Zealand Shipping Company Limited argued that they were entitled to the protection of the exemption clause contained in the contract between the shipper and the carrier. They claimed they were performing services as agents or servants of the carrier. Defendant's argument: A.M. Satterthwaite and Company Limited argued that the stevedore was not a party to the contract between them and the carrier, and thus could not benefit from the exemption clause. Final outcome and legal justification. Outcome: the Privy Council ruled in favour of New Zealand Shipping Company Limited, allowing them to benefit from the exemption clause. Legal justification: the court held that the stevedore was indeed entitled to the protection of the exemption clause. The decision was based on the following legal principles: agency and contract law. The stevedore was considered an agent or servant of the carrier. The contract between the shipper and the carrier intended to confer the benefit of the exemption clause upon the stevedore. Privity of contract and the Himalaya clause. The court extended the doctrine of privity to include a third party, the stevedore, in this context. The Himalaya clause, derived from the case Adler v. Dixon, 1955, was applied. This clause aims to extend the contractual benefits to third parties who are performing under the contract's terms. Key concept implication of the Eurymedon, 1975. The case set a significant precedent in contract law regarding the privity of contract and the ability of third parties to benefit from contractual clauses. It reinforced the application of the Himalaya clause, enabling third parties, such as stevedores, to invoke exemption clauses within shipping contracts. Key learnings: the doctrine of privity of contract can be flexibly interpreted to allow third parties to benefit from contractual terms if the contract explicitly or implicitly intends this outcome. The Himalaya clause is crucial in shipping contracts to extend protections and benefits to third parties involved in the execution of the contract. This case highlights the importance of clear contractual drafting to ensure all parties understand their rights and protections under the contract.